Hello and welcome to SBK Unplugged, Sheldon Bosley Knight's land and property podcast. My name is Kate Gould and I'm the host of the show. Today I'm in the studio with our lettings director, Rebecca Dean. Hi Rebecca, nice to see you again. Before we get cracking, big thanks to our friends at Mill Street for hosting us in their lovely studio. Thank you very much. So Becca, Renters' Rights Act. Obviously at the end of October it became law, and not long after we got the first phase of the implementation dates, for which are happening next year. So I thought it would be a good idea for you to just give a quick overview, and then we can go through the key points, of which there are 6, which are going to be implemented in the first phase, just so that we're all clear about what's going on.
No, absolutely, that's fine. So yes, 27th of October was the date that the Renters' Rights Act became law. And it is now an act and not a bill. I do still keep calling it a bill from time to time. I think that caused a little bit of confusion actually, because we had a flurry of phone calls the following day with, does this mean that Section 21s are now abolished? Does this mean my fixed term tenancy is no more? So I think saying that it is law from the 27th of October has caused a little bit of confusion with our landlords. But yes, everything is still as it is at the moment. But on the 14th of November, fortunately, we weren't kept in suspense for too long. We were given the implementation date of the 1st of May 2026 for phase 1 of the Act to be enforced. So it's going to be done in 3 phases, as we know at the moment, with the key parts, which we'll run through shortly, being implemented on the 1st of May. We're then told that later during 2026, the PRS database will become available. And this is where landlords will have to register themselves, the property and all of the information into a database. So it will then be information that's available, I guess for everybody. And then we are predicting that within the next 12 to 18 months, we will have the decent home standards, and we'll see the implementation of Awab's law in the PRS. Now that's something that became law in the social housing sector on the 27th of October. So our understanding on that is that it will be 12 to 18 months because the legislation is already written. Obviously just needs some amends to make it right for the PRS as opposed to social housing. But yes, phase 1, 1st of May 2026. So we've been given the time frame that we were promised, which is good. We were told that we would have roughly 6 months to be able to get ready. So that's now where our focus will be.
But just to be absolutely clear, it's business as usual up until the 1st of May.
Yes.
Right.
Yes. I mean, there are some changes that we will be making in the business where necessary, just because we feel it's right for our landlords. We don't want our landlords to be in a position where, for example, we're being led to believe that the notice period for a landlord, the 4-month notice that can't expire any sooner than 12 months after the fixed term has started. I think initially we were led to believe that would be the first fixed term that tenant would have had, but the latest information is that actually it's from the latest fixed term, which now tells us that it's not massively beneficial to landlords to have a fixed term now, because come the 1st of May, if they want to serve notice, or even before then or just after then, they've still got to wait that 12-month period, not to serve notice, but for that notice to expire. So there are changes like that, and a bit of a change in the advice and guidance that we're giving to landlords so that they're not in a position where they can't make a decision to move forward if they need to.
Right. Okay.
So
the 6 key elements of the first phase, I thought it would be good to run through them one by one so you can say what's happening and crucially what isn't happening, because I think that just in case there's any sort of calls for not quite sure. So the first one is the abolition of Section 21. Now this was the key measure, wasn't it?
Yes.
All the way through, going through Parliament. So what is happening?
So Section 21, which is currently the 2-month notice for the landlord to terminate a tenancy and obtain vacant possession, that will be abolished completely. We will no longer be able to use the Section 21 from the 1st of May. Now, we are being told that any Section 21s that are in place and still within that valid 6-month period, because that's how long the notice is valid for once it's served, they will still be honoured. We're also told that any that are currently going through a legal process to get vacant possession if the tenant hasn't vacated will also be honoured. But from the 1st of May, we will not be able to serve a Section 21 anymore. And if a landlord wishes to take the property back, they will only be able to do so for breach of tenancy under the Section 8, which is still, general practice anyway. So for rent arrears, antisocial behaviour, general breach of the tenancy contract or what comes under statute. In addition, they will be able to serve the ground one under the Section 8, which is vacant possession, so that they can either move back into the property themselves or have a family member, close relative move in, or the ground 1A, which is the new ground under the Section 8, which will be for a landlord to sell the property. Right. So what's important with both of those is just that the landlord is sure on their decision, because by using the ground 1 or the ground 1A, they can't then let the property for another 12-month period after the tenant has vacated, or from the date that legal proceedings have commenced, whichever is the latest one. So, it's really important the landlords are sure of their decision with that. If, and this is something that we have been asked a fair bit actually, if a landlord was to obtain vacant possession because of breach of tenancy, so rent arrears or any other tenancy breach, they will still be able to relet the property once they've got vacant possession. Right. Because they're not choosing to take the property back to either live in it or sell it. So those are the only grounds of which they will not be able to relet the property for another 12-month period. If there is a tenancy breach, they will still be able to relet the property once they've got vacant possession.
Right. Excellent.
Okay.
So the second one was the changes to fixed-term tenancies.
Yes, so there will be a ban on fixed terms. Any fixed-term tenancy that is running when we get to the 1st of May will automatically become a statutory periodic tenancy. So statutory periodics are something that we work with anyway when that initial fixed term comes to an end. If a landlord and a tenant don't agree on a renewal, whether that be for another 6 months or 12 months, it automatically goes onto a statutory periodic tenancy, whereby the landlord would normally use the Section 21 to terminate by giving 2 months notice. Obviously they won't be able to do that, but the tenant would usually give 1 month's notice in line with their rent period to give the landlord notice that they're vacating. That notice will be 2 months notice, and that notice can be given on any month of the tenancy from the tenant. So there won't be a fixed term. It will just be, well, we say a 1 month roll-on contract because that's generally what a statutory periodic is. But it would be 2 months notice from the tenant to tie in with the rent date when they want to vacate the property. And that will be from day one of that tenancy commencing.
Right. Excellent. Then there's a ban on rental bidding.
Yes. So, and this is something that we've seen a fair bit more of over the recent years, especially with the problem that we've got with stock versus demand, for example. Typically, we're getting more applicants now, and the landlords have more choice of tenants when it comes to securing a tenant for their property. So given that there is more choice, we can sometimes be in a position where we've got more than one application. And then what tends to happen is one applicant will offer more rent than another applicant, and then somebody else might offer a bit more than that. Or the landlord may say, okay, can any of them pay £50 more? And it's a question then to the applicant. And that would sometimes secure the deal for the landlord, and the tenant actually as well. There are also cases where a landlord may consider accepting a pet. And they might say, okay, well, the rent is £1,200 without a pet, but if a tenant wanted a pet, if they paid an extra £50 a month, they could then have the property with a pet. And the reason for doing that was because the deposit cap came in 2019, which meant that we were no longer in a position to take a higher deposit for a landlord. to protect against any damages that may be created by a pet in the property. So because the deposit became capped at 5 weeks of the rent, we had to look at an alternative way that the landlord could still have a little bit of extra protection against any damages at the end of the tenancy. But what it does mean when we say a ban on rental bidding is that neither of those scenarios will be able to be honoured. So if there are 2 or 3 or 4 applicants for a property and one offers to pay more than the other, we wouldn't be able to accept that, and the landlord can't accept that.
Right.
So it's not something that we can move forward with. If it is that there's going to be a pet considered, it will be at the rent that the property is advertised at, because moving forward from the 1st of May, the rent that the property is advertised at is the maximum rent that you can take for the tenancy at that time.
Right.
Okay.
Thank you. Then there is a ban on rent in advance. Talk to me about that one.
Yeah, so rent in advance, we don't tend to see too much of, to be honest. In some of our areas, we've had rent in advance paid mainly by internationals coming into the country that perhaps don't have the UK credit history that we need to see when we're doing the references, or perhaps don't yet have a secure permanent job appointment. So they would generally offer to pay 6 months rent in advance or 12 months rent in advance, which gives the landlord the security over that tenancy. We also sometimes see rent in advance where a tenant can't get a suitable guarantor. But mainly our tenants that go through the referencing process will normally pass that referencing process. They'd fit the criteria, and then there isn't an issue. But rent in advance basically is also being stopped. So because there will no longer be a fixed term, it's a statutory periodic tenancy, the tenant can only be asked to pay rent for that 1 month, for that 1 month ahead. Now, we have been given information that suggests that a tenant can offer to pay more rent to secure the tenancy, but we wouldn't be able to accept that from them until after a tenancy agreement has been signed.
Right.
So there may be a scenario where perhaps if we are dealing with international students or, internationals coming into the country for work, it may be that we're in a position where we can have a conversation with them, and if that is offered, we can then meet an agreement with them where we say that, once the tenancy is signed, we'd be able to collect an additional 5 months or 10 months, 11 months, whatever that looks like. But then in effect, you've still got a periodic tenancy that's running with that rent paid in advance. So it's then a question of what that looks like if the tenant chooses to terminate by giving 2 months notice. So there's still probably a few things to be looked into around that at the moment, but the general message on that is that we can no longer collect rent in advance for either a 6 or 12 month period. Any tenants that generally pay quarterly, we won't be able to accept that anymore. We can only ask for rent for the 1 month that is ahead.
So one month at a time.
Yes.
Right. Okay. Fifth thing is the ability for tenants to request a pet, and this has definitely been a bit of a hot potato, hasn't it?
It has, because it's one of the things that cropped up a fair bit at our landlord evening last week, where unfortunately some landlords have had a little bit of a bad experience before when they have accepted a pet in the property. But the message at the moment is that this applies to current tenants, so tenants that are already in situ, and it isn't applicable to applicants. Okay. Although saying that applicant could become a tenant and would then have the right to request a pet when they live in the property. I don't necessarily think this is a bad thing, because a lot of families do have pets.
Yeah.
I can completely understand why a lot of landlords wouldn't want to accept pets, but I think it's just about understanding from the applicant, or from the tenant, should I say, as to what type of pet it is, what its behaviours are like. Part of the legislation is that when a tenant requests a pet, they would have to include a photo of the pet and the full detail of it. So sure, we were getting to know quite a few cats and dogs and hamsters over the course of the next few years, but it has caused a little bit of nervousness with some of our landlords, and I think at the moment we just need information to confirm what a reasonable right to refuse a pet is. So we know that if there's a lease on a property, a landlord wouldn't be expected to breach the lease if the lease says no pets. If the property is not suitable, if it's got a very small garden, or it's a corner house without a garden and somebody wants a big dog, I think that I'm sure there will be reasons around that are considered acceptable reasons as to not accept a pet in the property. But I think one of the biggest things is just communication with the tenant, so we can talk to them about having the right insurance in place. We can perhaps talk to them about taking the deposit alternative, so that the landlord's got better protection at the end of the tenancy. I'm not sure how much of this we'll see at the moment. I'm very much on the fence with it, because we do get a lot of pet requests that come through and they're put to landlords, and generally a lot of them would be accepted anyway, because that tenant has already proved themselves to be a good tenant. So yeah, it's quite an interesting one that we need to see how it plays out. But generally, what that does mean is that the tenant will have the right to request a pet, and we're just waiting for further information at the moment as to what a reasonable right to decline would look like.
Right, excellent. And the final one is a change in increases in rent.
Yes, so rent increases at the moment, something that we're looking at all of the time for our landlords that have a managed service with us, because we want to make sure that their rent is at the right level for the market. Obviously, costs do increase everywhere. A lot of landlords have their mortgage increasing. So we do look at rent increases while we review the rents to make sure that they're at the right level all the time, and then have those good conversations with the landlords. Some landlords don't wish to increase, other landlords do. But at the moment, it's just 1 month's notice to the tenant to increase the rent, and that has to fall in line with the rent period that the notice does. So at the moment, more than one increase can be implemented in any 12-month period. Generally, we look at them every 12 months. So if we have a tenancy that's on a statutory periodic, we would review the rent every 12 months and then have a conversation with the landlord. But if we have a landlord that's had maybe a 6-month fixed term, they might want to look at a rent review after that 6 months has ended. We have some landlords that would have it written into the contract that there is going to be a review every 6 months. Obviously, any clauses like that are within the contract, they will be removed anyway. Yeah. They will no longer be valid, because the new statute will override what's in the contract. But what is changing there is that notice period to a tenant is becoming 2 months instead of 1. Must still fall in line with the rent period. So it's a clear 2 months for the tenant, and we have to now increase the rent, or we will have to increase the rent by using the automatic Section 13 process. So there is a Section 13 notice that is served upon a tenant to increase that rent formally. Now, some good news around this, because initially we were led to believe that we wouldn't be able to have a conversation with the tenant before that rent increase goes out. That's something that we like to do. We like to keep open communication. Where possible, we'd prefer to enter into negotiations between the tenant and the landlord to meet a rental figure that is suitable for both parties. And we would prefer to do that because it means that everybody's happy, we've communicated it in the right way, and it also reduces the tenants proceeding with the first tier tribunal to have their rent increase looked at. And that's something that can happen also from the 1st of May. We want to try and avoid that where possible. We'd rather keep a happy landlord and a happy tenant. So the good news is that we can now still have those conversations before that Section 13 is issued, which is really good news, because I think keeping those open lines of communication are really, really important. Just having that dialogue, I think it's just part of building the relationship with the tenant as well as the landlord. So if we're in a position to still have the conversations, we will hopefully be able to agree on what that rent increase looks like, and then we will issue what's called the Section 13, so that rent can formally be increased from the said date, which means that your landlord and your tenant are both happy. But I can't think of any other changes around that probably need to be discussed today. It's just the fact that it is Section 13 and that notice period is changing.
Right.
Okay.
Brilliant. Well, thanks, Becca, very much for that. And I'm sure that as more information comes out from government, we'll be updating our landlords further. But But for now, it's business as usual, and we wait for the 1st of May.
Yeah, I mean, we'll be preparing as a business to make sure that everything that needs to be in place is in place. So I guess that further information that we're waiting for at the moment is the notice that will go out to all tenants to let them know that their fixed term tenancy is now a statutory periodic. Obviously, we'll have new terms of business to issue to all of our landlords. So all of our landlords will receive one of those, because we'll need to make sure that it ties in with the current legislation. We're just waiting to understand what additional clauses need to go into that contract to make sure that that's compliant. Obviously, we'll have clauses around the fixed term tenancies and Section 21 notices that we'll need to remove. So there's a lot of work to be done behind the scenes with our documentation. And that's all to obviously prepare ourselves as well as the landlords. And then over the course of the next kind of 5 months, we will just be making sure that regular updates go out. So yes, as and when any more information becomes available that we think landlords need to be aware of, we will be issuing that either in an email update, through video content, through another podcast. We'll also be keeping in touch with our suppliers to make sure that if there are any changes on their part, we're in a position to communicate those as well. And then we'll also be making sure that we put on training sessions for our staff. So those will be internal training sessions, probably held by me and the senior lettings team. So we can make sure that all of the staff are fully up to speed with the changes, with what that means for our business, with what the impact is, what the changes in our processes need to be, and also to put them in a position where they can talk to our landlords as well and have good conversations with them. Without feeling nervous, without feeling like they don't have the right information for them, and so that landlords can also be kept informed and have the trust in all of the team within the branch rather than just speaking to the manager. So yes, lots to be done. Lettings is always busy, keeps us on our toes. But I think at the moment we're definitely in a good position, and we'll be ready for it.
Brilliant. Well, thanks so much, Becca, for coming in and explaining all the changes that are going to come in from the 1st of May.
No, thank you for having me.
And thank you so much for watching, and we will see you again next time.